All right, well, let me get started. This is exciting. This show is literally hosted by the Institute for Global Compliance. For more information on the Institute, you can visit the directsellingsolutions.com website. The Institute was founded by Doris Wood, God bless her little soul, and Troy Dooley and I several years ago. Membership information is on the site. The Institute is just starting to grow and build its community. So in the future, we'll introduce more information about it. It's going to be an institute where compliance people can come together and get educated. So we are ready to rock and roll. Welcome, everybody. I am so excited this call got started correctly. All right. Well, let me share with you a couple of pieces of information. This is the Direct Selling Show, May 28th. And our topic today is, does the FTC have your company in its crosshairs? And that is an important question to ask yourself. Now, on today's edition of the Direct Selling Show, we're going to be talking about the FTC's recent two letters that they had sent in to the DSA and the DSSRC. Kevin Grimes and Clay Brewer are going to answer questions throughout our show, and we're going to identify ways to know if the FTC has a target on your back. We'll review 4 things. I'm sure we'll review a whole lot more than 4 to reduce your regulatory risk. And I'm going to tell you a story about getting caught in the wrong place at the wrong time. When the regulators came knocking, I happened to be there. So, does the FTC have your company in its crosshairs? This is a scary question to ask, but we've got some answers coming up. And I don't mean to get people concerned, but you would be smart to build up your defenses now. We also are going to be talking about what those defenses are. So there's no time after a crisis for preparedness. That's my favorite statement. And we're going to talk about that. Once the crisis arrives, there's no way to go back and create your compliance documents. So we would encourage you to do that before anything happens. And of course, we've got free legal advice for your questions. If you have a burning question for Kevin or Clay, please post it in the chat now, so we'll be sure to get to it. All right, well, enough of all that. Let's get started. I'm Donna Marie, in case you don't know me, Donna Marie Saratella. A lot of you know me as the Queen of Compliance. I'm a writer, speaker, and a compliance expert in the industry since 1991. Now, over the years, I've been the secret weapon attorneys call on when they need help with compliance, field compliance. And that's why they call me the Queen of Compliance. I don't want to sound all high and mighty, so I just want to help companies and their distributors. Now, I'm thanking our sponsors right now for being on the show today. Our sponsor is Thomas Burton Law Firm. With offices in Nashville, Franklin, Tennessee, and Huntsville, Alabama, the firm has 42 lawyers. I had no idea. They had 42 lawyers. They've won 4,100 cases and over 2,700 happy clients. So thank you, Kevin Thompson, for being our sponsor. Bottom line, our sponsor has you covered for all your legal needs. Give them a try if you need to talk to somebody. And for the questions, we're going to be seeing those on a private chat, and I'll be able to answer those and give those to the attorneys to answer as well. So join us regularly on the show. We'll be having the show on, I believe, the 3rd Thursday. We'll get the schedule out to you as soon as we know. So a couple of people have asked me before we get started, and Rick Gray was so sweet to remind me, my book, Compliance Solutions, What the FTC Won't Tell You, We Will. If you'd like a free copy of that, put your name with book in the chat, and we'll be happy to pick someone out of the group and send them an autographed signed copy. And it's on Amazon if you're interested in looking at that. Now, the Direct Selling Show has had some wonderful industry icons, such as Kevin Thompson, Robert Butwin, and Joe Kennemore. Maybe you saw Kevin Grimes and I on Kevin, the wildly popular show that we did on the FTC and the Penalty Offense Authority. 2 years ago, we did that show. It was a real cliffhanger. I would invite you to go to my YouTube channel, which is Direct Selling Solutions, for previous direct selling shows. Many of the shows do feature different people on the show, but the attorneys are on there talking about the different things. As I've mentioned, we have hosted the one and only Kevin Thompson on the show. Kevin had an interesting post on Facebook recently addressing the non-competes. That could probably be a show in itself. So in his recent Q&As, go back and watch Kevin Thompson's post and sign up for his newsletter. He'll appreciate that. It'd be great for you because he has wonderful things in his newsletter. So here we go. I'm so honored to have these two speakers today. We've had them on the show before, and we'll have them again. You'll be seeing a lot more of them. And if you could put in the chat what shows you'd like to see, if you've got somebody in mind that you'd like to have on the show, we would love to invite them to be on the show as well. So allow me to shift to our introductions. Now, neither one of these people need to be introduced, but I'm going to definitely share a couple of things with you on each of them because, well, they're very special gentlemen. They've volunteered their time to be on the show today and in the past, and I'm sure I can twist their arm to be on the show in the future. So we're thrilled to have them. They each deserve to be recognized for their contribution of time today, but their contribution to the direct selling industry is unbelievable. These two gentlemen are there for a phone call, a text, an email for their clients anytime they need them. And it's great to work with both of them. So let me share with you a little bit about Kevin. Kevin Grimes, I've known for over 30 years. You could say we both grew up in the direct selling industry together. He is an exceptional lawyer. I'm telling you, he is one heck of a FDA lawyer, FTC lawyer, all the initial lawyers. I believe first and foremost, he's an exceptional person. Kevin loves God. He loves the Lord with all his heart, and he is a walking example of God in action. Kevin has a heart bigger than Texas. He has fostered over 35 teen boys, adopted 4 or 5. I can't keep up. But once you get to know Kevin, you would agree with me that the boys have the best dad ever. So Kevin's resume includes a who's who of the industry since 1990. He has shared his vast knowledge of FTC, FDA, and MLM law for over 32 years with over 1,500 clients. That's amazing. Kevin's an attorney with Thompson Burton Law Firm, the premier law resource, and especially experts in the direct selling law arena. Before we get started, I've just got a quick question for Kevin, and then I'm going to introduce you to Clay. Kevin, what did I leave out of that introduction that you want listeners to know about you?
I think you hit,
let me
yeah,
see.
it was more than enough.
More than enough. Okay. What drew you to this aspect of practicing MLM law, Kevin? What did that for you?
Well, it was ultimately a recruiter that brought me on board to start the legal department at Melaleuca 32 years ago. So I was Melaleuca's first in-house attorney. They were about 7 years old at the time, growing very, very rapidly. Well, actually, my real start in direct selling was on the distributor side, not the corporate side. In the late 80s, I got involved with a little company probably nobody on this call's heard of, out of Michigan, called Amway. And great experience. Didn't make much money, sponsored about 10 people. Then I got involved with another direct selling company, a company called Niken. And so, yeah, yeah, I mean, I was definitely attracted to the industry on the distributor side first. Then I had the opportunity to come in on the corporate side, and I've been here ever since. It's as an attorney, it's a lot of fun. My clients, I mean, I've certainly had some interesting clients. The vast majority of them, by and large, are a lot of fun. Just good people trying to make a difference in the world. So I've stayed.
Thank you very much. We appreciate you being here. And we appreciate the fact that you're in this industry. You're a wonderful representative of the industry. Well, let's talk about Clay Brewer. I am so impressed with you, Clay. Your MLM knowledge is superior. At first, when we met, I said this last time on the show, I was a little skeptical of the new attorney. There's a new attorney in town. Then I learned of his background. I worked with him on a couple of clients, and he was just a delight to work with. Clay is an attorney with Thompson Burton as well. He has an extensive background in law, both in direct selling and a wide range of corporate matters, such as business planning, capital raising, corporate structuring. And in addition, Clay is the author of Thoughts of Bruin newsletter. So you definitely want to subscribe to that. He also serves on the ethics board of the ANNP. And overall, he is one really cool guy. Clay and his wife just had a baby, and it's not too soon ago. It's been about 9 or 10 months now. She's in the
Yeah,
labor
time
baby.
flies.
Yeah, congratulations to you and your wife. Clay, how's that little one doing? Getting big, huh?
She's doing great. Yeah, she's starting to crawl around, so you have to start chasing her. So that's always keeping us busy. But
And why did you choose MLM law for your practice? What got you
yeah,
started?
so I kind of fell into it. During COVID, I graduated law school during COVID, and I ran into Kevin Thompson, and that's his specialty. And then working under him, learning under him, and I just kind of yeah, fell into it. I fell in love with it. I grew up around the industry, so I went to a lot of corporate events with my mom. She was a distributor in a well-known company, so I kind of knew that side of things. And so it's really cool being on the other side, being on stage at different events and things. Looking back, I know I was always a little kid in the suit, wanting to be like those people. So it's really come full circle.
Well, we're glad you picked law. It's a great field for you, Clay. Thank you for being here. So I do consider myself very privileged to work with these gentlemen, and I'm honored to work with them as well. A couple of great guys. Now we are live. This is different. Some podcasts record. We're live each and every time. So this is giving you a chance to write in and ask questions. Tell us who you are in the chat, and if you have questions, we'd love to have them. Now let's jump in here. We want to know, does the FTC have your company on in its crosshairs? And we'd like some keys to reduce those regulatory risks. So let's start with Kevin. Kevin, how are you going to know if you're in danger of being in the crosshairs?
Well, you can't know. You can, I mean, and we've actually done this in the past, approached the FTC about a particular client to ask whether the client's being investigated. And in fact, it was, but the FTC won't tell you whether it is or is not. I had another client many years ago, pretty famous, Burn Lounge. And it's very interesting. Burn Lounge found out that it was being investigated by the FTC because representatives from the FTC's Atlanta office were having lunch with some members of the South Carolina Attorney General's office, and one of Burn Lounge's top distributors was in the booth next to them and overheard it. And so it got tipped off that way. But generally, there's no way to know. Now, as hopefully a lot of folks on this call, or maybe everybody on this call knows, the FTC has sent out 2 notices under their penalty offense authority. They sent out one in October of 2021 regarding income claims, and they sent out one in April of last year regarding product claims. The income claims one went to over 1,100 companies. They weren't all direct sellers. Amazon got some, Uber Eats, DoorDash got some franchisors got some, but over 600 direct selling companies did receive notices. Now, these notices, didn't mean that these individual companies were doing anything wrong. Under the penalty offense authority, the notice has to basically put an entire industry on notice that, hey, we, the FTC, say there's an illegal practice going on, and we're kind of defining the parameters of those illegal activities, in this case income claims, and then also last year in product claims. So it puts companies on notice that the FTC has a very high level of sensitivity regarding a particular issue. Also, the fact that a particular company received one of the notices indicates that the FTC is aware of your existence. But more importantly, the FTC is monitoring what these companies are doing. So, historically, I mean, since 1996, the FTC has relied on its, I call their litigation strategy, the silver bullet one-shot judicial assassination litigation strategy. They recently lost the ability to continue to utilize that strategy in a unanimous decision by the U.S. Supreme Court. And so that's when they decided to dust off an old remedy that they had, the penalty offense authority, which really hadn't been used much since the 80s. But the bottom line is, yeah, there's no way to know whether a company's in the crosshairs. When you look at stuff that's coming out of the FTC, most recently it's letters to the DSA and to the DSSRC. An argument could be made that the FTC is still has heartburn about the entire industry. But at the end of the day, it's really largely about target acquisition. Yeah, the FTC wants scalps on its TP, but particularly after its very, very recent loss in the Neora case, Neora case, the FTC is still licking its wounds about
I love that sense of accomplishment. Don't you?
Oh,
guys?
yeah.
Don't you? I
I will
thrive
be
on
going to
that.
bed tonight.
If we
feeling
can mute that person.
You'll feel a little better
So-
tonight. That's
Yes,
for
I
sure.
will.
Yeah. So anyway, there's no way to definitively know whether a particular company is in its crosshairs. For me, the issue, I like to go to the polar opposite end of the spectrum. It's like, let's talk about thermonuclear scorched earth best practices so that, your company is an absolutely horrible target for the FTC or any other regulator.
Fantastic. That's what we want, is no targets. What about the TINA? Is TINA a precursor to trouble when you get the Truth in Advertising involved, that group? When you get a letter from them, or when you get a letter from the DSSRC, Kevin, would that indicate that there's trouble on the horizon?
It could. I mean, on the one hand, and Clay may be able to speak to this better. To the best of my knowledge, I don't think that any case that whether it's TINA or DSSRC has been taken up, or any case that TINA or DSSRC is forward to the FTC has been taken up by the FTC. Again, Clay may correct me on that. But and again, TINA's from where I sit, TINA's perspective is, every direct selling company is illegal. But at the same time, I mean, they certainly do have some expertise, and particularly the DSSRC. I've had several clients who have interacted with the DSSRC. Those guys are fantastic to work with. We don't always agree on everything, but I certainly would counsel any client to give a serious listen to whatever either organization has to say.
The DSSRC, just for questions on the call, if somebody doesn't know about that, that's the Direct Selling Self-Regulatory Committee or Commission. I'm not sure what the C stands for. Council. And they are a regulatory, are they a regulatory council? That's what they are. And
Well,
then
they're part of the
letters
Better,
out.
yeah, they're part of the Better Business Bureau.
Right.
I don't know the precise genesis of the organization. I think it was kind of a collaborative effort between the DSA and the BBB to be self-regulating. So here we are.
Yes. Well, let's switch over to Clay and ask him about any additional signs a company may be in the crosshairs. What do you tell your clients, Clay? When they ask you that question, or when you discover that there's an issue, what do you tell your clients?
Yeah, there's not much to add to what Kevin just said, but I think the biggest understanding we try to get across is that the industry is not liked, and so I always advise that the entire industry is in the crosshairs, and so it's best practice to set up appropriate compliance, appropriate record keeping. So in the event they do come knocking, you can prove what it is you're saying that you're doing. We've seen, I think the biggest dichotomy is between, like, the Neora case, for example. They had lots of record keeping that kind of pushed back on the FTC's initial claims, and the FTC couldn't rebut that again, so they couldn't take it further. A lot of companies that get shut down and the FTC ends up winning, they just can't rebut the claim. So if you are having customer sales, or if you do have a large number of your distributors who are purchasing for perhaps discounts as opposed to the income opportunity, a lot of companies have no way of proving that. And so the FTC is going to win the day. And so I think it's the best assumption to assume that all companies are in the crosshairs, and just you don't want to be the slowest person in the forest when a bear's chasing you, right? That's kind of the best way to go about it. Um, and then when it comes to who they choose, there's really no rhyme or reason. When it comes to notice of penalty offense making authority, those letters they sent out,
Mhm.
I think they just did like a simple Google search because a lot of the companies, or many of the companies, not a lot, are no longer existing. So it seems like they just did a blitz to the industry to kind of support what I just said about the whole industry being under attack.
Mhm.
And I think that's the biggest angle to take. Just prepare for the unexpected because I've seen, to be frank, completely atrocious companies slide under the radar for years. And I've seen companies who are on the line or even doing things right just get attacked. And um, a lot of companies don't have the wherewithal that Neora did to spend that money to prove that you are acting in compliance. So
Mhm.
that's usually how I go about it.
Mhm. Well, Neora did an excellent job, from what I understand, of their compliance efforts. And the good thing that I find about that is the ones that don't do a good job are putting themselves at the wrong end of the stick. They're
Mhm.
just silly for not having their compliance ducks in a row. Um, Maybe they had less of problems because they had a robust compliance department. But what do you say? What do you say, Kevin, when you discover that an owner has absolutely nothing set up for compliance?
Yeah, I think the Neora decision, the district court decision, Barbara, can't remember her last name, did a fantastic job of just laying out a great roadmap for the industry. And so any company executives who are on this call, I would absolutely recommend that they really read and digest that opinion, because this was a trial. This was a judge alone trial. And the judge decided whether the FTC's allegations that Neora was a pyramid, that it was making improper income claims, improper product claims. The judge made a decision. Of course, those decisions are based on evidence. And so, to your point, Neora did a great job of being compliant and substantiating its compliance efforts with a lot of evidence. And it had great evidence, had great facts when it came to income claims and product claims. Now, what's interesting, I think Neora was started in 2011, 2013. And initially, they were out there with respect to income claims, but um, shortly after the FTC initiated the lawsuit in 2019, it really worked to clean up its income claims, making big progress in 2019 and 2020. And it was interesting because the judge called the FTC's claims or assertions about improper income claims stale in light of the company's more recent efforts to clean things up. And it cleaned them up quite well. It published quite a bit of guidance about how to make proper income claims. It gave the field do's and don'ts about income claims. It made sure that anything containing income claims had appropriate disclosures, disclaimers, and links to the company's income disclosure statement. They had a monthly compliance corner newsletter or email or some type of communication that went out. They did a really commendable job of training. And so all of these things came together in a really, really nice pile of evidence to refute the FTC's allegations that the company and its distributors were making improper income claims. Because better than the vast majority of direct selling companies, Neora went the extra mile and then some to make sure that it and its distributors weren't transgressing when it came to improper income claims and improper product claims as well.
Mhm. Mhm.
So again, it's great roadmap.
Yeah, definitely. I'm definitely going to get a hold of that document and read through it and highlight with yellow marker because I want to see exactly what they did. Heard it was a great job.
Mhm.
Clay, what do you do to convince an owner to do the right thing about compliance when really they're afraid it might hurt their business? It boggles my brain because compliance is so important, yet they think it's going to hurt the business. What do you say to that, Clay?
Yeah, it's difficult. I don't know if I do a very good job of convincing companies sometimes. That's definitely the hardest part. I think our job as lawyers is not to dictate how entrepreneurs kind of run their business, but more so expose them to the risks and the laws that are out there and things like that, and let the business owners kind of dictate how they go forward. Because I mean, to put it simply, following the law will hurt your business to an extent, right? So if you're not just making all these claims, if you're not, I mean, if you are making all these claims, if you're trying to push product no matter what happens to whoever and just require your distributors to purchase the product and just rack up money quickly, you're going to see competitors that are doing that thing. And so being compliant might put you at a disadvantage to your competitors. So that's the angle that I kind of try to angle when companies come to me. So you need to think about viability and longevity as opposed to a quick buck. And if
Mhm.
you're in it for a quick buck, then it can't help you really, I mean, we really don't want to work with you if you're not trying to do things right. There's a lot of gray in the industry, so you can work with them in that regard. But if you want to kind of skirt the rules to get that quick buck as a company executive, as opposed to really trying to grow your product and have that culture and have that brand,
Mhm.
that's really the biggest distinction: quick buck versus longevity and establishing a brand and a product you believe in. So,
And I'm glad you mentioned longevity because when I'm working with these clients and we've got one right now, it appears some owners have no regard for compliance. They get started with their compliance efforts, and after 60 days,
mhm.
bam,
Yeah,
bam,
and it might
no more compliance.
Yeah, and it
Uh,
might hurt your business in the short term, but if you're willing to push this 5, 10, 15, 20 years into the future, then a lot of those companies that were beating you at the outset are probably no longer in existence, right? Or
mhm, mhm,
they've gotten in trouble for some variety of reasons, things like that. So that's usually the biggest argument, that if you're willing to be here to stay, then you need to do it right, and you will be successful. Because it's my opinion, this is a great industry. It's a great way for individuals in the field and executives to grow a brand and things. So
mhm,
that's usually the
mhm.
argument that I make. It
You
seems to
know,
land with those that are wanting to do it right. If you go into it with the bad reasons, then usually that compliance argument doesn't land too smoothly. But you learn very quickly.
yeah, to Clay's point, one of the things we've learned is that clients come in three flavors. There are those who know how to do it right and want to do it right. There are those who aren't exactly sure how to do it right, but they want to do it right. And then the third category is those who do or don't know how to do it right, but they couldn't care less about doing it right. It's we work with the first and the second categories. The third category is, as soon as we find out that that's the category we're in, we'll fire them. For better or for worse, I've had a handful of clients that wouldn't take my advice on compliance issues. And I'm not going to mention any names, but, I can say, hey, these companies have been put out of business, and the principals of these companies are still in prison as we
Mm.
speak. So, you want to go there. And interestingly, two years ago, I was at an industry trade association gathering, and after the first day, I checked my emails and found one by an FBI special agent who was working with the U.S. Attorney's Office investigating one of my former clients who wouldn't take my advice. It was interesting. The principals were all offshore, and the U.S. attorney handling the case said, "We're going to go to every single country and get these guys." And thankfully, I had a nice 50-page opinion letter, CYA. But yeah, it's like, okay, you don't want to address compliance issues, fine, you'll do so at your peril there. And as attorneys, I try to, we try to be very, very careful and to not wax into fear mongering and stuff like that. But we do want to paint a very accurate picture of the regulatory landscape. Hey, if you're serious about compliance, what's really interesting is I would argue that compliance isn't bad for your business. It's ultimately really good, because what's interesting in direct selling is that, in most industries, yes, the legal interests and the bottom line business interests are diametrically opposed. But here, they're really aligned, because what's great for your business? Answer: telling the truth. and having lots of customers and selling lots of products to lots of customers. That's great for the bottom line, and it's great from a regulatory and compliance perspective as well.
I love your famous line about the customers. Go ahead and say it.
Yes, the biggest secret in direct selling, I mean, clients pay us billions of dollars for this secret, is customers are good for business. Yeah. But I mean, historically, I say that a bit tongue in cheek or a bit corny, but historically, customers have been kind of a heresy or a non-issue. I mean, for many decades since the inception of the industry, there's this what I call the Ice Age paradigm, which was, hey, priority number one is distributor recruiting, priority number two is personal consumption by distributors, and priority number three is teaching your new distributors about priorities number 1 and 2. There are still lots of individuals, lots of corporate executives, lots of field leaders who still believe in that old paradigm. And I hasten to point out, I don't know if you've noticed, but there are no more dinosaurs roaming the earth. We all know why. Ice Age, climate change. They didn't have the ability to adapt. We're going through a climate change, regulatory climate change in the direct selling world. And the question, and we've got a lot of dinosaurs. And the question, it's not, are they incapable of change? It's an issue of, are they willing to change? And I'm concerned about the ones who aren't willing to change to the new paradigm, in which priority number one is customers, customer acquisition, customer sales. Priority number two is distributor recruiting. It's an integral part of this business, but it's not the most important part. And then priority number two, or number three, is teaching your new distributors about the proper place of priorities number 1 and 2. But but everything else, and particularly the compensation plan, has to support those paradigms as well. So anyway, I'll get off my stump about that.
Oh, no, we love to hear it. Customers are a good thing. They're good for business.
They are.
They are.
And that was another place in which Neora just shone. The judge, said that 75 to 80% of the company's revenues were generated by its preferred customers, not brand partners, not distributors. That's really, really significant. And the judge teed off on that over and over and over again. Great.
Fantastic information. We do have a lot of compliance managers and directors listening to the podcast. And, I've talked to them before, and a lot of them are in the same boat when they go into their supervisor and say, we need this, this, and this for compliance, and it's going to help the business grow faster, not the opposite. And, they get shot down for wanting to have a compliance corner or create a new IDS, the income disclosure statement. Maybe they had one from 3 years ago, and they go in and say, let's create the new IDS, boss. And they get shot down for that. Clay, what do you, what's the priority there? Teaching the person that's trying to get the idea across, or getting to the supervisor and saying, hey, I want to shake them. I just want to shake them. I don't know. What do you do, Clay?
Yeah, so I mean, Kevin will definitely, I'm sure, back me up on this, but an income disclosure statement is probably one of, if not the most important item to have from a compliance standpoint at this point. Not only because of the recent guidelines that the FTC has sent out to the DSSRC, but also because of the penalty offense authority. And so any company that's been made aware of that offense, it's $53,000 inflation adjusted per claim that's being made. And that's not just by the company itself, but also by the distributors, because they're acting as agents on behalf of the company. And so the argument goes, the company benefited from these claims through sales, therefore they're on the hook as well. So it's really a non-starter when it comes to income disclosure statements, telling the truth, being full and transparent. Now there's more guidance on, you need to include expenses. We've kind of been preaching that for a while, but the FTC is hammering that away now. So for example, if an individual makes $1,000 per month, that's great. But if they spent $2,000 to get there, then their net is negative $1,000, right? And so that's definitely relevant for an individual joining the company. And again, if you're open and honest about this, it's not a bad thing. It's the problem when you're trying to slide customer numbers under the rug or force individuals to buy product and things like that. It comes out in the numbers, and I think that's why many companies maybe balk at not presenting them. But
Mhm.
an income disclosure statement, an IDS is, I think, the end all be all at this point of the industry.
Mhm.
It's
And
really
oh, go ahead.
unfortunate that, in the Federal Trade Commission, um, we, they're really, with regulatory agencies around the world, again, the US is an exception. Regulators see themselves as wearing two hats. First and foremost is as consultants to industry to help industry comply with the law. And then secondly, when individual players do not comply with the law, then they put on their law enforcement hat. The Federal Trade Commission only wears a law enforcement hat. And I would say its lack and its unwillingness to give, good guidance to industry is really a third world approach. I mean, it's like a petulant child, if you will. And I don't mean to be on a rant, but it's just ridiculous that the world's leading consumer protection regulatory agency has not attempted in over 40 years to provide the direct selling industry with definitive guidance about income claims. And the reason I say 40 years is because this is when the seminal MLM income case in Ray National Dynamics was adjudicated by the FTC and bounced back and forth between the U.S. Court of Appeals. So that case was great because it really articulated what is required in a proper income disclosure statement to handle about 6 different categories of income claims. In addition, and like I said, in 2021, the FTC cranked out its notices under its penalty offense authority regarding income claims. So it articulated 8 or 9 different categories of income claims that are deceptive, but did it provide any positive, definitive guidance about, hey, here's how you can make sure that you're making proper income claims? Absolutely not. And it was interesting because, again, the judge in the Neora case highlighted that fact too, that the FTC has not provided any helpful guidance whatsoever. So it's, from my perspective, the FTC is just really a mess. It's, it got spanked spanked hard in the Neora case. The judge teed off on its 2004 advisory opinion to the Direct Selling Association. So, in its letter to the DSA, the FTC has nixed that and said, hey, we're withdrawing it. It's no longer valid. Even though we gave this guidance, now it's not guidance anymore. And so, for corporate leaders, and again, for compliance personnel, for, chief legal officers, et cetera, it's a tumultuous, challenging place to be. So, because we don't have clear, bright line guidance on anything. And so, my encouragement to, to executives at any level is just always think in terms of thermonuclear, scorched earth, absolute best practices. That's the key. And we do have a fair amount of guidance there. Again, starting with the National Dynamics case and, culminating most recently in the New York case, we do have a lot of really, really good guidance about things that companies can and should do.
Mm-hmm. I agree. And I'll step in real quick as well. Not to make this a promo or anything, but this is why good counsel and good compliance is so important, because from the most recent FTC advisory opinions, both to the DSA and the DSSRC, we're operating in an aura of subjectivity. And so there's no clear guidelines. There's just, well, we might think this is wrong, or we might think this is right. And so you need to kind of put arrows in your quiver. So in the event something were to come up, you have these things in order that you can present to then ideally refute those claims.
Yep, get your ducks in a row before the disaster occurs, because once the crisis arrives, there's no time for preparedness. That is the bottom line. So what should companies do if unfortunately one of the folks on the call today gets a little note from the FTC or the DSSRC or the TINA? They definitely need an attorney to answer them. I've been involved in quite a number of them where the owners answer them and respond without their lawyer's opinion, which just mortifies me. But what do you do when they get a love note from one of these, regulatory agencies? Clay, what's the first thing we've got to do?
So it definitely depends on where it's coming from for starters. If it's the FTC, you need to get good counsel and absolutely respond. When it comes to the SSRC, again, the FTC just pretty much said ignore their guidance. But as Kevin said at the outset of this call, I still think that they provide good guidance. And so doing the dance with them, with Peter and everyone at the DSSRC, I think it would act as a good test run, really. I mean, they're really great people there. They want to help the
Mhm.
industry. They're obviously pro industry, so they're not going to just send gotcha questions and things like that. And so I think doing the dance with them to see what might be going wrong, because they might have caught something that's minor, or they might have caught something that's just absolutely gone crazy, and the FTC hasn't gotten wind of it yet.
Mhm.
I would like to advise clients, yes, the DSSRC, nothing that they have referred to the FTC has been taken up, but I'd hate for you guys to be the first, right? That'd be a
Mhm.
terrible look, and just I think it's worth doing the dance
Mhm.
because they're pro industry. Um, Personally, so I haven't dealt with Tina directly, but if I were to receive something from them, I'd be a bit more cautious because we know the angle that they're coming from. I don't think engaging with them really provides any type of benefit. They are anti-industry. They've been to anti-MLM events. There's no ambiguity in their position. And so
Mhm.
I think it is more of a gotcha game. And of course, it would depend on the context and everything, but I would, broadly speaking, not engage with them because there's no benefit to that. Take what they say to you, maybe um, to help your compliance, but there's no reason to really do the dance with them and engage with them and make sure that they're happy because they won't be happy. So
Mhm. Mhm. And not to answer the questions on social media. Boy, oh boy, I've seen that happen as well. They just get in there and want to defend themselves on social media. And that
yeah,
could put yourself in a serious spot.
it can damage a lot of egos, especially when you see a lot of kind of scorched earth in the negative context, and not in the compliance context. When these industry or agencies or whatever you want to call it go public with things, but
Mhm.
you can use the First Amendment in certain extents to refute false claims and things like that. But there's really no benefit to engaging openly with them,
Mhm. Mhm.
especially if they're going to try to take your answers maybe on stage at one of their anti-MLM events someday. So.
Mhm. Kevin, Clay mentioned a $53,000 fine. Now, how does that work? So let's say I make income claims and my company gets in trouble for me making one income claim. Doesn't it add up? Or how does that work if a company's in trouble for income claims and they get them on uh, several of them or just one?
Yeah, several. So yeah, the penalty or the maximum penalty under penalty offense authority, like Clay mentioned, is $53,000 plus or minus. And it's for each instance of an improper action. So let's say you have 10 distributors making 10 improper income claims per week. Okay, that's 100 per week times 4 weeks in a month. So that's 400 times, let's say, 6 months. So that's 2,400. Multiply 2,400 by, let me see,
54,000?
54,000, 50. Let me just see what that would be. It's a big number. Okay, it's only 127 million. So yeah, but so then the FTC will send, a notice and a bill to the company saying, hey, just remit your check for 127 million. And we'll be good. And so, what's going on right now, since they sent out the notices back in October of 2021, is they're watching companies. Yeah, like Clay mentioned, a lot of companies are out of business, but the ones that aren't, I'm very confident that the FTC's monitoring these companies and their fields, and what they're doing. And I don't know when, but one of these days, companies are going to start getting bills from the FTC. Now, just because the FTC says, "Hey, you've done this," just like they did with Neora, they alleged all sorts of deceptive income claims, and the federal judge said, "Nope, sorry, you lose. You didn't present sufficient evidence to, to prove by a preponderance of the evidence that they have done this. So, so just because a company gets a bill from the FTC doesn't mean they have to pay it. They absolutely, positively can and should litigate something like that.
Have any companies been fined through that program to date? Do we know?
Well, none of the recipients of the October 21 or the April 23 penalty offense notices have been tagged yet that I'm aware of. Now, when they initiated the penalty offense authority in the 80s, I think what set it all off were manufacturers and marketers of bamboo fabric products, which in fact were rayon. And they definitely did go after some folks back then, even some department stores, for claims they were making. I don't remember, how much, the fines were, but they certainly have used it in the past, and they certainly have tagged companies in the past.
So get real, do your marketing correctly, or go to jail or pay a huge fine. It's your choice.
Yeah, well, it's just, again, just think in terms of, some of my foster kids have struggled with criminal thinking. And the way criminal thinking works is like, okay, what do I want? Okay, I want this thing. Do I have the money to buy it? No, I don't. Well, then I just take it. Well, if I take it, what's the likelihood I'll get caught? It's a completely messed up type of thinking. But we see the same thing in direct selling, with some companies, some entrepreneurs. It's a, hey, how long can I get away with this mentality? It's like, you don't want to even go down that road. You shouldn't think that way. You should be thinking, rather than what can I get away with, is like, what are the absolute thermonuclear scorched earth best practices? And, to all the compliance managers and compliance VPs, who are on this call, that's my encouragement. Hopefully you can beat that drum in your companies. And it's like, that's, hey, that's needs to be our focus, just best practices, because that's what's best for our business and the bottom line in the long run.
Best practices. Let's talk about the IDS a little bit more, because I have a question for both you and Clay. This question about the expenses. There's a lot of talk about an affidavit, truth and accuracy, confirming this information that people are making with income claims. Where do we get the affidavit? Who has that?
Yeah, so we first started hearing about expenses when Bill Ackman, the hedge fund manager, came after Herbalife back in, I don't even remember which year that was. But
2011,
he
I think.
was it? Yeah, so he was arguing Herbalife had something resembling an income disclosure statement. It wasn't adequate. It was called Statement of Average Gross Compensation, but it didn't have anything about expenses. He contended it was deceptive, and of course, he eventually ended up losing a whole lot of money on his shorting of Herbalife. But and so, yeah, as Clay mentioned, we've seen the FTC grousing about that in its letter to the DSSRC. But again, what's interesting, and I think a lot of that is the FTC's attempt to push back against the decision, of the federal judge in the Neora case, because the FTC made the same argument in that case, and the judge pushed back and said, you know what, no, they've got some other really good, disclaimers in there that, talk about, hey, expenses vary, they do broach that, but, in terms of being able to provide a number, an exact number, it's going to vary widely from distributor to distributor. So again, the judge did not buy the FTC's argument.
Good. We're glad they didn't.
But as Clay pointed out, the Neora did a great job of marshaling evidence, to make its case. And they didn't survey their people about expenses, which again, I would argue that would be a good thing to do. So if you could, so if a company could publish, companies, some companies have to survey their distributors anyway. Well, one of the elements of an income disclosure statement is that you have to disclose the minimum, maximum, and average amount of time the distributors at each rank in the compensation plan work their business. Okay. Most of the information that has to be reported in an income disclosure statement, the company already has. It's already in its databases. But a little bit of information that even now needs to be reported in an income disclosure statement companies don't have, and they have to poll their distributors to get it. And this, how much time do you spend working your business, is one of them. Well, if you're polling them about that, how about you poll them for their expenses too?
But how many owners are really going to poll their distributors and ask them how much time and how much expense? And where do we get that affidavit? I'm not sure I've ever seen one that says,
I don't think
I
you have
swear
to
to
have
God, this is what I've earned.
Yeah, no, I don't think you need an affidavit. I think just having a service statistically significant survey will get the job done.
Okay, sounds good. I wanted to bring up those 4 documents that I sent out with the invitation. And I want to talk about the endorsement and testimonial guidelines and advertising. I was going through it and I was seeing how they had the 4 things: the written permission, the substantiation, the typical results, and the clear and concise disclosures. That all made sense to me. Then I heard something, where did I put it? About dark something or other. I was like, what is that? Hold on, let me see if I can find it in my notes. Oh, no, I can't.
Dark patterns, is that what it is?
Yeah, what is that, Clay?
So that's kind of I mean, it's somewhat related to the industry, I suppose, but that's more so the FTC taking a stand on junk fees. So yeah, that's a bit outside the scope of the industry.
Kind of outside
Just
of
pretty
our,
much, yeah, just
yeah.
don't hide fees. Like you say something's, I don't know, $5.99, for example, and you get to the very end of the checkout and it's $25, things like that. So the FTC, a lot of that's in recent cases the DOJ is bringing against Ticketmaster and things like that is more so the applicability of the convenience fees and things.
Okay.
But it is applicable to our industry, of course, because you always see that limited time offer, and then you keep kind of upselling each funnel an individual clicks through. That would be somewhat the relevancy for our industry, but not a terrible of concern.
Okay, I just didn't know what that was. I went through it and I was like, I never saw that before. Let's jump to the second letter that the FTC sent about the pyramid scheme analysis. I really wanted to get your take, both of you, on that and find out what your thoughts are. Kevin, do you want to start us out with that conversation? We only have a little bit of time left, so answer concisely instead of in lawyer language.
Okay. Well, I think the bottom line is the FTC had a massive loss in September of last year in the Neora case, and the judge disagreed with quite a few of the FTC's attempts to characterize the state of the law, and the judge pushed back and said, no, that's not the way it is. So here in this letter, the FTC is again attempting to say, hey, this is what the law is. Well, the FTC can't do that. The FTC can't make law. Only Congress or the courts, by a case law can do that. So the letter, it's important to understand that the FTC's letter is merely its opinion as to what the state of the law is. Well, again, it asserted that position in the Neora case and just lost miserably. So again, I think the letter is just largely whining and grousing by a petulant regulatory agency, that's still licking its wounds.
Okay. Well, I want to remind everybody that Kevin and I did do a show on the Penalty Offense Authority. Go to YouTube and find the show. It is so riveting. It is the most exciting show we've ever done, Kevin. It was marvelous. We had hundreds, if 10 viewers. Oh, well, let's hear a couple stories if we can, real quick. Clay, do you have any stories about the situation where it was just so far gone they couldn't save the day, you couldn't save the day, or maybe a story where you did save the day with something? What do you see in the industry that you can share with us? Do you have a story?
Nothing too specific, but I can give an example or two, I suppose.
Okay.
But also when it comes to dark patterns, I just want to step in real quick. So that's when you make it hard to cancel as well. That'd be considered a dark pattern. So we have to call and
Oh,
jump through hoops, things like that. I just wanted to kind of
okay.
where it's applicable to the industry to some extent. Um, but when it comes to, don't really have any horror stories, knock on wood, right? Which is great.
Uh,
But the biggest thing is that a lot of companies, I think, especially startups, believe that it's easier to start a company and will cost less funds than it truly does.
mm,
And compliance, legal counsel, things like that are always the last things to go. And we try to do like legal reviews and kind of give our recommendations at the outset of the company getting going. And then they'll disappear for a year or 2 or 3 years. Then they might find themselves in the weeds with the FTC doing the dance, and they're still doing things that we recommended them years ago, or it's gotten worse, or there's no way to prove what they're saying is going on. And then with us not being there with them, there was no way for us to really know. And so I think just that we've seen this multiple times that um, take your time in starting a company, and then also take your time in developing a company, and don't be afraid to shift gears, because it's an evolving field. It's more of an art than a science, especially with the subjectivity that the FTC and other regulatory agencies are working under right now.
mhm,
So I know it's not like a crazy horror story, but that's kind of just the general theme that I've come across
mhm,
daily. So,
mhm. Kevin, do you have any stories that are,
I've I got more stories than we have time for, unfortunately. But I mentioned 2 years ago going to an industry event, coming back, checking my laptop. Whoa, here's an email from an FBI special agent. Said, "Hey, we understand you worked with this particular individual, this particular company." I didn't remember either name. I check my lap, I do a search, and it's like, oh yeah, I worked with this company 5 years ago, and the company wasn't willing to listen to my advice. And so, as part of, unfortunately, as lawyers, what we have to do in this age of just hyper litigious regulatory agencies is we have to protect our backsides when clients won't take our counsel. So I actually prepared a 50-page opinion letter about this company and its program and sent it off to them and immediately fired them. Well, so anyway, so they, the U.S. Attorney's Office ultimately sent me a subpoena. I checked with bar counsel here to like, can I disclose this? Should I disclose this, et cetera? So anyway, so they got their hands on that smoking gun. And then about 6 months later, same special agent, same group at the U.S. Department of Justice investigated another one of my clients that wouldn't take my advice. Again, same smoking gun. So my point is, if you get an opinion letter from your attorney that you didn't ask for and you didn't pay for, you should be very scared because that attorney is doing some thermonuclear CYA.
ouch, that's a good thing to remember.
Yeah. We haven't talked about this, but, product claims, obviously, lots of companies, especially companies in the consumer products arena, make a lot of product claims. And, a lot of companies really play fast and loose with their substantiation. The bottom line is any claim, any type of safety or efficacy claim companies make regarding their products and that distributors make regarding the company's products need to be substantiated by competent and reliable scientific evidence. An individual's experience, a testimonial, that's anecdotal evidence. Case studies done by doctors, anecdotal evidence. 1,000 case studies are just 1,000 pieces of anecdotal evidence. They'll never rise to the level of competent, reliable scientific evidence. And companies need to understand that because, again, we got, the penalty offense, notice a year ago on the product claim side. So companies need to be careful. Here again, Neora, did a good job according to the court. Had lots of compliance related resources and training about, hey, folks, you can say this, you can't say this about our products. And, even if this is your personal experience, sorry, and if it's not contained in official company materials, and again, they just did a really, really, really good job of educating, training, monitoring what the field was saying about their products.
And that's what you've got to do. You've got to do the actual work involved in running a compliance department. So you know what your people are saying, you know what's going on there. I have so many questions. I made a bunch of questions in case anybody didn't have questions. So I have questions like, how might the rescinding of the 2004 letter affect the regulatory landscape? That's a good question. Well, I really want to know about that. I've got questions about how do companies demonstrate transparency in their compliance department to avoid being classified as a pyramid scheme. We have lots of material for more shows, is what I'm telling you. We definitely do. And it's already 10:35, so we have to wrap this one up. But we really appreciate both of you. Let me just see in my notes. Boy, I have so many questions about the income disclosure statement and the pyramid scheme analysis. It's just, there's not enough time. We'll do another show. That's it. If I can get you both to agree on another show, we'll do another show. Why don't we do a quick wrap up? Clay and Kevin, I'm going to ask you to wrap up your comments in 2 or 3 minutes here, and then we'll move on for the next show. Kevin, do you want to wrap up for us? And then Clay.
Well, like I mentioned earlier, I definitely would encourage everybody to take a good look at the Neora decision. The court did a great job of highlighting all the things that Neora did well, did right, and to make its case and refute the FTC's allegation. So it's kind of a great measuring stick for the rest of the industry. So I definitely recommend that. On the income claims side, I've been writing about income claims for decades, developed, probably the first income disclosure statement for the industry back in the mid 90s. I'll be happy to send a really long-winded, boring article about, the regulatory requirements regarding income claims and, what a model income claim disclosure statement looks like. If anybody's interested, they can just, put something in the chat or email or something like that. But, the great news is none of this is rocket science. It's just about, best practices. And again, in our industry, compliance best practices are really great for the bottom line. They really are.
Mm-hmm. Absolutely. Clay, what about you? You want to wrap up? And then I have to tell everybody about what happened to me when I was in the wrong place at the wrong time.
Yeah, I think the biggest thing that I come across with companies is just take a step back and think about maybe why the rules are the way they are, starting with Costco in 1975, and then kind of how the industry has evolved, and whether rightly or wrongly, what the FTC is seeking to do, and create a business model or record keeping or all of the above that kind of flows with that dynamic. It's still a great industry. We don't want to convince individuals to leave the industry whatsoever. We think there's a lot of growth here too. At least I do. I don't want to speak on Kevin's behalf, but I love working in it. But we have to do the dance that's required of us, right? So we can complain about the FTC all we want, because I have plenty of gripes to take up with many regulatory agencies. But understanding where they're coming from, I think, will help a lot of companies move forward successfully, as opposed to just thinking we can't do this or we can't do that, or how are we going to survive kind of thing. That's been, I think, the best advice that the clients have received, and they've really given feedback in that regard.
Mm-hmm. Well, thank you, Clay, very much. We appreciate you. So let's consider the actions that we take together to foster an environment of compliance in the MLM industry. We can safeguard both the consumer interests and the integrity of the direct selling company. If we could do that. All right, let me tell you real quick, because we're running behind, but I did keep the call going until 10:45. So tell you a quick story. I was in the wrong place at the wrong time. December, January of 2002, I was a consultant to a direct selling company. I was in the ladies' room washing my hands when the loudest bang came on the door. Boom, boom, boom. I mean, it was like just unbelievable. I realized it was a front door to the office that I was working in. And I was on assignment in Fort Lauderdale. It was a startup MLM. They were in serious trouble. I was working with Jerry Nura, excellent attorney. He has since retired. He and his wife are doing great. But to continue, I was in the ladies' room when the attorney general, the FBI, the police, the radio stations, they had everybody in the hallway coming into this office. And they made us get out of the bathroom and go back to where we were. And unfortunately, I was working at the owner's desk that day. So I went back into the office and marched myself right to the owner's desk and sat down at his desk. And they came in and thought I was the owner, but I wasn't. And that got cleared up real quick. But we called Jerry. They let us call after they read this huge, long search warrant. The regulators thought the company was involved in organized crime. And if you know my last name, Donna Marie Saratella, it was not good to be on that side of the street with a name like Saratella. So it was a real mess. Jerry used to tell me all the time, and he still mentions it, to side yourself with the angels. And in this case, I was not sided with the angels. So I wound up working for the attorneys to assist with the case for over 9 months after they were shut down. And it was a nightmare for the owners, the customers, the distributors. I was definitely in the wrong place, wrong time, but it turns out because of the industry that I'm in and what I do for a living, it was one of the best educational experiences of my life, because I got to see what happened when they first come knocking and the chaos the investigation caused to the entire company. So there was no turning back at that point. Anyway, I appreciate everybody being here. Clay, any final comments?
I think I'm good. Thank you.
You good? Kevin, you good?
Nope, I'm good.
All right. Well, thank you all for being here. And remember, I'm the queen of compliance and I'm always watching. So remember to spread the word about this call to other people that are in the compliance industry. Owners, we would love to have owners on the call. And we encourage you to come back for another call. We did what we said we were going to do. We covered the FTC letters, talked about the ways to see if you have a target on your back. We covered the 4 things. So I think we did a really great job. Thank you guys for being here. And thank you everybody for being on the call today. So have a great one.